Miigwech everyone for coming today. And yeah, like Jeremy said, my name is Andrea Gallagher Courteau, but I just mostly go by Andrea Gallagher. But I also want to introduce myself in our language, my family's language, by saying Anin, Miskwe, Mikinake Kwe, Tishnikas, Mkwato Dem, Sagkeeng the Donjba. And today I'm going to be talking about the Indian Act and gender discrimination. I'm going to just take this out maybe. As I think is customary now, I was going to start with a land acknowledgement, acknowledging that we're here gathered on Treaty 1 territory at the Treaty Relations Commission, which is wonderful. Manitoba is located on territories and ancestral lands of the Anishinaabe, Anishinaabe, Dakota Oyate, Deniswalene, and Hindowak nations. Manitoba is also the homeland of the Red River Métis, and northern Manitoba includes lands that were and are ancestral lands of the Inuit. It's also important, I think, to acknowledge that here in Winnipeg, our water comes thanks to Shoal Lake First Nation in Treaty 3 territory, and the hydroelectricity that helps us give this presentation today and put it online and all that great stuff comes virtue of the Treaty 5 waterways of northern Manitoba, and thanks to the First Nations impacted in that territory. So I'm going to be talking first a little bit about the role of women pre-contact. So a bit of traditional life for Indigenous women, and to set the context of what was normal prior to, what we know as like settler colonialism. So women, and we still say this today, as we are reclaiming a lot of our traditional ways and our traditional knowledge, that women are sacred, and that was always very important. Women are sacred. Why are women sacred? I think a great part of that being that women are life givers. Women have this power to give life, and that's woven into our teachings, it's woven into our ceremonies, it's really woven into everything we do and what we are as Indigenous people, is this really valuing women and the connection to life, the connection to Mother Earth. We refer to Mother Earth and have great reverence and respect for that. So the ability for women to feed and nurture their family, not only is it important, when a baby's born, it is the mother that feeds that baby. And beyond that, it was also the role of the mother, of the woman of the household, to continue to feed, to do that gathering, that real hard work in the household. And part of that is also being teachers. So women were the teachers of the culture, of life skills. They were the first teacher, and they still are in, I think, many families. Your first teacher, my mom was my first teacher, and I think that that's really important, that influence that the women have. So furthermore, women would hold power. So outside of the family, women held this power through strong kinship ties. That's just relating to how the different families worked together, what was the place, and providing that organizational, know-how within the community. Beyond that, managing the home also meant managing the resources of that home. So whereas sometimes it was the men to go out and to do the hunting, but once it comes home, it's the women who are doing the management of what was brought, right? And making sure that it's being used appropriately, making sure that it's going into clothing, going into what are the needs of the household. And I find I'm still doing that in my own family, what are all the things that we need in this household? I think women are still very much the managers of the household. So that was obviously very much present pre-contact as well. They were also, because of this, the advisors within the community. So I think the advice and the impact of what women thought was also important. That was taken by the men as important because of their knowledge, because of their influence, because they had this respect for women, for their roles, for those responsibilities that they held. So they also had personal autonomy within societal structures pre-contact. So women were able to move about. Women could make decisions. It wasn't based on what the man in that family or the man in that community. And beyond that, there was this, there was a matrilineal line in some communities, in some nations. I believe the Haudenosaunee people have a matrilineal line in their history too. It very much follows the women. It was not uncommon for there to be women leadership, but also the women who were giving the advice gave the advice as far as leadership, and they could remove men from that leadership position if the community of women found that that leadership was not acting within their interests and the interests of the family or for the whole. So they did have some title. They were they had property, so they really had a lot more rights. So what we're going to see when we get to even the treaty system is the confrontation between these two ideologies. We look at the treaties, and I think in many different ways, we're looking at treaties as it's Indigenous law and Western law and the confrontation, and we see to this day the misconceptions brought by treaty negotiations, and that also went so far as to include the role of women in those treaty negotiations. So treaty negotiators, because these were Western men who came from a different background and a different perspective on gender roles, would not negotiate with men or with women. So that meant that the women had to put forward, and that doesn't mean that women weren't involved in the treaty process. That doesn't mean that they didn't make their beliefs known, their concerns when it came to treaty negotiation known, but they were not allowed to participate in an equal way to men because of the Western patriarchal lens that was being applied at treaty making from the Crown. So there was also no recognition of the roles and responsibilities within treaty for women. It wasn't explicitly set out what was the roles and responsibilities of women. Again, because you're looking at treaty making from the text anyway, from a Western lens. So the language used within the treaty indicates the difference in this gender ideology. And I think there's been many who have kind of noted that despite there being some of the language that was used, for example, the Great White Mother, using the term mother to indicate that relationship to the Queen, is different for the interpretation for the First Nations people during this treaty making than I think that many have said was intended by the Crown that was using this turn of phrase, this Great White Mother and her red children. They were meaning it, from their perspective as like a mother and children, boards of the state kind of interpretation of that relationship, whereas it's seen as, a caregiving, it's seen as a relationship as First Nations people know it between, a mother or even like Mother Earth and Indigenous people. So I think there were initially some differences there that perpetuated a bit of the misconceptions. So moving along, because we talked about the treaties, which is great, and I think there are some misconceptions there, and there has been some problems there, but I always like to say that the treaties were intended to be a reciprocal relationship, that it was intended to be of mutual benefit, and it was, especially at the beginning, for, friendship, and, there was this positive history on treaties and negotiated benefits. However, the entire history is muddied up by the Indian Act. So prior to the official Indian Act was the Act for the Gradual Enfranchisement of Indians. So again, Indians being the term used at the time, and unfortunately because of the Indian Act, still the terminology used to describe peoples today. So the gradual enfranchisement of Indians. So Section 6 of this is where we see the initial marrying out clause. So this says, quote, provided always that any Indian woman marrying any other than an Indian shall cease to be an Indian within the meaning of this act. Nor shall the children issue of such a marriage be considered as Indians within the meaning of this act. So that's the initial time we see that, once you marry out of another, if it's to a non-First Nations or a non-Indian, then you're no longer considered to be an Indian, as well as the children of that family. So it goes on to say that, provided also that any Indian woman marrying an Indian of any other tribe, band, or body to which she formerly belonged, and become a member of the tribe, band, or body of which her husband is a member, and the children issue of this marriage, shall be belong to the father's tribe only. So Section 6 not only sets out the marrying out, but also that it's intentionally to follow the male line. And even if you're to switch bands, it must follow that male line, which again is in contrast to the pre-contact, societal structure that First Nations people were accustomed to. So Section 9 of the Gradual Enfranchisement of Indians was about the property ownership. So it begins there as well, this impact of the patriarchy. So upon the death of any Indian holding under location title any lot or parcel of land, the rights and interest therein of such deceased Indian shall, together with his goods and chattels, devolve upon his children on condition of their providing for the maintenance of their mother. So the property and all of the ownership would go then to the children, who then the children were responsible for the maintenance of the mother. It bypasses the female role entirely at this point in time, so that the property ownership was not really up to the woman at all. She had no say in what happened to that property. So Section 10 within this act stated that the governor may order that the chiefs of any tribe, band, or body of Indians shall be elected by the male members of each Indian settlement. So essentially women were forbidden to participate in political life. There was not only a new system for politics that was imposed, and that's what we today call like band chief and council. So this system, in many cases, completely foreign to those pre-contact societies, now had, this system which was entirely patriarchal, and women had no influence. So Section 14 of the Act discusses that if any enfranchised Indian owning land dies without leaving any children, such land shall escheat to the Crown for benefit of the tribe, or his father or mother belonged. And if he leaves a widow, in that she shall, instead of dower, to which she shall not be entitled, have the said land for life or until she remarries. So in this case too, the widow could hold land, but only until she remarried, in which case that land was then stripped from her. And she would, again, then be expected to fall under whomever she married. Whether that was a First Nations person or not, that outcome depended on that. But obviously, as well as if she dies and it reverts back to his parents. So that property always followed the male line. So Section 16 of this Act followed much of the same, in that the name and surname by which he or she who is enfranchised and therefore known and receiving letters in such name shall be held enfranchised, and his wife and minor unmarried children shall be held enfranchised. So essentially stating that voluntary enfranchisement by men, because of this act, which I think is always interesting to note that they expected there to be a high amount of voluntary enfranchisement, of which there was not, and therefore resulted in many amendments to the Indian Act, which perpetuated more involuntary enfranchisement methods. But the voluntary enfranchisement extended to the wife and children. They had no say. As soon as that man made that decision, he made that decision for his wife and for their children. So obviously a large impact there as well. So then we move on to the actual Indian Act. So the Indian Act, 1876, keeps a lot of the same things that the Gradual Enfranchisement Act introduced. So it defines all the Indians in reference to their relationship with a man. So it goes a little bit further in stating that the term Indian means, one, any male person of Indian blood reputed to belong to a particular band. Two, any child of such person. Or three, any woman who is lawfully married to such person. So the entire identity is really framed around the man. Furthermore, down in that same section, it provided that any Indian woman marrying any other than an Indian or non-treaty Indian shall cease to be an Indian in respect within the meaning of this act. So I think that that's really interesting too, to make that distinction that is not just marrying anyone other than an Indian. They also were inclusive of non-treaty. So the treaty was really important, not only in our benefits, not only in the negotiation, but in the way in which it was tied to identity and how that impacted women too, who was treaty and who wasn't treaty. That really has been, really essential to our identity. So Section 5 of the Indian Act says the term enfranchised Indian means any Indian, his wife or minor unmarried child who has received letters patent granting him free simple. So again, all framed, to be the enfranchisement inclusive of the wife, same thing as before. But Section 9 is a little bit different than what the previous one had, where, you know, the talking about the estate and who receives what, because it says the right and interest therein of such deceased Indian shall together with his goods devolve 1/3 upon his widow and the remainder upon his children equally. So no longer was it up to just the children, and then it was up to the children to then take care of the mother. It was 1/3 was up to the mother and then the rest to the children. So again, that, I don't know if that's better, but it's also not seeing the woman or the wife as an equal partnership to the man. So it goes further on, reaffirms in section 61 that those eligible to vote in band elections were only the men in society, in Indigenous First Nations. So that continued on through the Indian Act for quite some time. And then section 72 of the Indian Act describes the loss of annuity payments. Again, something brought in through treaty is, you know, this annuity payment that was negotiated. But there was the power to stop the payment of annuity and interest money of an Indian who is guilty of deserting his or her family. So this was inclusive of both of deserting their family. However, it goes on to say that the same may be applied towards the support of any family. So a woman who was deserted could also lose, you know, their annuity payment, could also lose their livelihood simply by having been deserted in accordance to, you know, whomever recognized that this family breakdown had occurred. So another way in which particularly women were harmed through the Indian Act and through particularly for the annuities in this section. So it says that also to stop the payment of annuity and interest monies to any women having no children who deserts her husband and lives immorally with another man. Again, putting the morality on the woman rather than on the man. Very distinctive in the language of the Indian Act. And then in more in section 88, much of the same. Unmarried children will also be held as enfranchised. It kind of reaffirms that. But then in section 93 of the Indian Act, there was the enfranchisement for his or her exemplary good conduct and management of property. So if you were to conduct yourself well and be proving to manage your property well, proves that he or she, in this regard, seems that they want to be a little more gender inclusive, he or she is qualified to receive his or her share on money and then be enfranchised. If such Indian be a married man, then he shall also be paid for his wife and minor unmarried children. So if a man was seen to be a good property owner, to be of good conduct, whatever that meant, they had a bit about, you know, having had like 2 years of good conduct or whatever the different parameters for that was, meant that if he's enfranchised, then you get payout for the women and children because they're not really considered on their own. However, a woman on her own, if she was of good conduct, could also be enfranchised and received her share of money. So how were all of these things decided? So who decided the good conduct? Who decided how all of these policies, how the Indian Act would be applied? And so this is the Indian agents. This is the role of the Indian agents. So the Indian agents were the representatives of the First Nations. Indian agents were sometimes referred to as superintendents. And they were meant to administer or enforce the Indian Act. So The Indian agents existed between about the 1830s to the 1960s, where you saw they kind of diminished, and then eventually the role of the Indian agent was repealed. So I think it's really important to note that Indian agents were almost exclusively non-Indigenous men. Again, you know, Western patriarchal system, these kind of positions of authority are held by men. So Indian agents were more likely to be, or to have been, local missionaries, or perhaps farmers from the area. So there was somebody who was selected from the area who was reputable, who they thought, you know, could keep an eye on things and would be able to understand, because I think that was a big part of this role, was understanding the conduct, understanding a bit of, I suppose you could say, the local politics of all of this, and the families and all of that, because, you know, what they needed them to do and what they needed this policy to be implemented. So it was also somewhat desirable. I think a lot of people, you know, would understand that having this position of power and authority in your area would have there'd be a bit of an attraction to that. But also, they were significantly paid, more than a lot of other positions at the time. So they received, I think it was $900 to like $2,000 annually, which at the time was quite a bit to be paid to be an Indian agent. So this is maybe on top of if they had a farm or whatever their other source of revenue for this non-Indigenous man might have been. So it could also be, in some instances, a stepping stone into other positions within the civil service. Kind of like today, you get into the civil service, you can move your way up. There were instances of Indian agents. Some, you know, had no desire to do so, but some did have the desire to move up the ranks and work for the Department of Indian Affairs. So it was also a bit of a pathway, and I think colored some of the policy from that perspective as well. And because, you know, there were some who went into this managerial or civil service role, they also, it was an Indian agent who was the inventor of the pass system. So the pass system itself disproportionately affected women. The pass system was a system that limited mobility for, you know, all Indians, all First Nations people. But for women in particular, it cut off these kinship ties. You had no other resources. You weren't allowed to leave the First Nation. If you had family outside of it, it was less likely you would receive a pass to go to another First Nation. It diminished their influence. They really were, again, very much stuck to their First Nation unless receiving a pass. And it increased scrutiny, especially when it came to, you know, those First Nations who had nearby white settlements. They didn't want intermixing with the white settlements of these First Nations women, so they were relegated to the First Nation, not allowed a pass. So not only mobility rights, but that really cuts off any economic opportunity for these women to do any other, you know, jobs, to kind of fend for themselves. And even, you know, kind of relates into the possible pathway, and they were particularly harsh on potential prostitution. So I think a bit of a controversial topic, but that was another way in which not only were they being relegated, but could be particularly harmed because of the harsh treatment from either Indian agents or RCMP for the First Nations women. So the role of the Indian agent I have here is really like important, because there's that role of informant. That was how, you know, they had this information of what was working, what was not working, because they report up into a bureaucracy, into the Department of Indian Affairs, whether or not these policies are being followed, if their assimilation tactics are working, and they're able to pass along this information that, as somebody who works as a policy analyst, really informs how we create policy that we want, to guide things a certain way. So they had that really important role, but I think also, and very harmfully, was the significant amount of power that they wielded. So when it came to their powers, they included the conducting band elections. So obviously we set up a system for band chief and council elections. It's not up to the First Nations to then just do that however they wish. There are regulations and codes according to the Indian Act and how they want that to happen. Ensure that it's men that are voting. Ensure that it's being done a certain way. It was the Indian agent who kind of oversaw the band council elections and recorded the results. So he presided over all of those meetings as well in that very in a patrilineal kind of way. So also the Indian agent decided who would have access to housing on the First Nation, who would have access to social services within that community. So he really was able to wield a lot of power for what women had access to, and would enforce those gender norms that it was, the men of the household, and if there were women who, applied for services, they were able to deny that. Furthermore, recording of marriages on a First Nation, so that was then also to be recorded by the Indian agent, and then the enfranchisement that goes along with kind of what I described, with the goal to assimilate, that enfranchisement when everybody is enfranchised, or if they're deemed appropriate to be enfranchised according to, at different points, they have more methods of enfranchisement. I just kind of listed the ones that are, based on gender, but there's many more methods of involuntary enfranchisement that then the Indian agent could decide, this person should be enfranchised. So they had that ability and were able to record that at the local level. They also were instrumental in the managing of wills and estates. So all of the economic prosperity, there was also the need for permits, economic permits if you wanted to sell goods, wares, if you were hunting, you were selling any of that, the management of meats and things, that also required a permit. Those permits were to be held by the Indian agent, who could deny you the ability of that economic resource. Also, they served as justice of the peace, ruling over minor incidents. So there is no real judicial system as we know today. There was really just the Indian agent when it came to some of these minor incidences or concerns. And then another really important point, that they were also the purveyors of assimilation through the residential school system, ensuring that children did attend residential school, or sometimes even picking who was deemed appropriate to go to residential school because of their knowledge of families and dynamics, and who was maybe too old and wouldn't be able to be assimilated. They were able to make some of those decisions, who could go and who could not, and enforce those cultural bans. So there were significant cultural bans, ban on spirituality, ceremony, all of that was carried out, not necessarily enforced, because you can bring in the enforcement and the policing and the RCMP to assist in that, but the determination that things are happening, and that at what point do you bring in that enforcement to ensure that the bans on those cultural activities was happening. And again, they themselves, Indian agents, were a source of gender-based violence. So women, through all of these methods, through all of the different ways in which they needed to ask permissions or permits, or they were not in charge of their own destinies in First Nations, the women themselves were in a vulnerable position when working with an Indian agent. So they suffered their own physical and sexual abuse. There are documented allegations of this abuse perpetuated by the Indian agents themselves on First Nation women. They also have been noted to have been complicit in the forced or coerced sterilization that also occurred for First Nations women. So some major changes came to the Indian Act in 1951. And some of those, good, but many of those not good enough. So major changes to the Indian Act included that much of the language, if you look at the document itself, much of the language changes from he or the man or, male persons. It's really focused prior to 1951 on the man, and then in any reference being the wife or the children of the man. It changes to now being person-based. So it reduces some of that, that very glaringly obvious gender discrimination. It also brought about the dissolution of the past system. And it also ended the ban on cultural practices, at least insofar as they were not deemed illegal. That still doesn't mean that it wasn't frowned upon. It doesn't mean that it still wasn't persecuted in a societal way post-1951, but the legality of it was repealed in the Indian Act in 1951. The right to hire a lawyer was reinstated. This is something that was illegal for First Nations people, but obviously a woman who was in need of a lawyer was ineligible prior to 1951. So there's many different reasons for which I think women would be in need of a lawyer. And First Nations women were, at this point, granted the right to vote in band council elections. So this is almost 100 years of having band council, chief and council elections, and women were not allowed to participate until 1951. So that's really a long time to really ingrain that politics is the place of men in this new society that's been created. And I think we see the effects of that, and we've seen male leadership from First Nations politics ever since. The female presence has grown in modern times. There's been a bit of reclamation of the power and place for women in Indigenous politics, but it had lasting effects because you could not even participate in a legal sense until 1951. And I mean, that's beyond looking at it from a federal perspective, where in Canada, like, as Indigenous people, as First Nations people, we still couldn't vote federally, right, until 1960. So male or female. But at this point too, I think it's really interesting that, non-Indigenous women had the right to vote, and Indigenous women, not only did they not have the right to vote, but they didn't have the right to vote within their own societies as well. So an even longer fight for suffragettes for Indigenous women. First Nations women, so the end of forms of involuntary enfranchisement, there were some of the forms of involuntary enfranchisement that were lessened, but it's still really enforced in 1951, the marrying out clause. So this still discriminated against women, as it granted status to non-Indigenous women at this point who married out. So Indigenous women who married non-Indigenous men, they lost their status, but at this point, the non-Indigenous women who married Indigenous men gained status. So this also created an inequity that we're going to see there's a lot of repercussions of. So it also introduced this double mother rule. So this targets the female line in that it strips status from an individual if their mother and paternal mother acquired status through marriage to a status male. So this idea of getting status through marriage for the women, like there's also that limit through the double mother. And I think it's also important to note the impact of a creation of a central registry. It was at this point that we had the federal registry created for the Indian Act rather than the local levels that previously had, the status, and that really meant that status equaled band membership. Now we've changed this in subsequent decades, where now we can have our own band membership codes, but there was a point in time that starts really in 1951 and goes up to the 90s or even 2000s at some point where, band membership and status really were very much interlinked, and there is some harm that comes from that as well. It really diminishes First Nations' ability to self-determination and their use of sovereignty. So talking about the issue of status and Bill, let's just say C-31. So Bill C-31 passed in 1985, and this was an amendment to the Indian Act, and the purpose was to remove this gender discrimination. And this was in part because, at 1985, they're really being pushed. Had been a lot, and I think it's important to note, Indigenous women were not doing anything about this. Like, they were advocating. They were, really trying to make their voices heard. And also at 1985, when we have just pushed through the Charter of Rights and Freedoms, it's really kind of impossible to move forward and not address the gender discrimination that existed within, Canada's own legislation through the Indian Act. So to make it consistent with Section 15 of the Charter of Rights and Freedoms, women could now apply for reinstatement of their lost status. So those who were impacted of the marrying out specifically could apply. And while this looked good on paper, that, you can get your status back, it was not that simple. The process, as a lot of government processes can be, and I say that as a bureaucrat, is very, cumbersome. And that then fell on those women who were already vulnerable, who were already, I was going to say disenfranchised, but enfranchised, right? They did not have their status, therefore they did not have access to services, rights, all sorts of assistance that would have been afforded them prior to losing their status, and now they were expected to go through this government process to get that status back. And that included an application, and through that application, you also had to receive the permission of your First Nation to receive you back as a member, which may have been very difficult at the time, because suddenly all these First Nations are confronted with a wave of women who are applying to come back, and as I think we all know, First Nations are already stretched on the resources front. So to suddenly be confronted with a lot of women who may want to return, what does that mean for their resources? Then it's my understanding, my teaching, that they were, asked, some of these women were asked, are you expecting to come back here? And they could have been denied because they may not have had the ability to take them on as a member. They may not have had space. They may not have had housing, which is still a problem, is housing on our First Nations. And beyond that, any other resources for them and their children who may want to come back to the community. So you've disrupted an entire family system and kinship system, and then suddenly to have them back may not be easy for the First Nations to take on. So it wasn't as easy as just applying and getting it back. As well, it costs your annuity payment for the year, is what I was told anyway. So that you also had to pay an administrative fee to receive your card back. So it was obviously very much worth it, and like a lot of processes, it also took time. Many women took, at least a year to receive their status back. And so it addressed some of the harm, but there's still gender discrimination that existed. So this idea of a second generation cutoff, and you can kind of see it through the diagram here. So a 6-1 being the description of a First Nations person under the Indian Act is Section 6, and then there's 6-1, which is essentially describing a full-blooded Indian, and then Section 2 is that which has some mixed ancestry. So if you have the 6-1 plus non-status, how you receive 6-2. So I myself was considered, a 6-2 because my father is non-Indigenous. So, but if you have a 6-2 and then another non-Indigenous, then the children, that's your second generation and you're cut off. And I think it's important you're cut off from then having those ties, you're cut off from all the things that come with it, inclusive of your treaty rights, which was never part of the conversation. That was never part of the intent of treaty. So very problematic. So gender discrimination continued to exist. Bill C-3, and then there's subsequently Bill S-3. So these are important amendments that have happened, in the past 25 years, 20 years. The 2007 BC court case of Sharon McIver, she was a woman who regained status after the passing of Bill C-31. And she was not able to pass on her rights to descendants the same way that a man with status could. And that was her argument, her case against the federal government. And in the British Columbia court, it was ruled that Section 6 of the Indian Act did, in fact, deny McIver equality rights under the Canadian Charter of Rights and Freedoms because of that. So she won that, and it made changes. You see that through this diagram here, how a brother and sister are differently treated, whether it became a 6-1 or a 6-2 previously under Bill C-31, and then after her case, where they both became a 6-1. So again, really important, but this question mark here is still missing. So McIver had brought her case to the United Nations Human Rights Committee as well, arguing that the Indian Act was discriminatory. So she did a lot of advocacy at federal and international levels. And then in 2017, there was Bill S-3, and this is the act to amend the Indian Act. However, it was not fully enforced until 2019. So this extends the entitlement to descendants of women who had been impacted by discrimination dating all the way back to 1869. Now, this is where I'm at the question mark. So, because I would be here, and then my kids were, prior to this, I mean, my oldest was born in 2019, thankfully, but he would have been then considered to be the end of the line, the second generation cutoff, and my son would have not been First Nations. He would not have had a tie to our community, our culture, all of those things. He would not have status. However, because of Bill S-3 and because my mother lost her status through marrying my father, and we had been impacted, just like this case. My son is now the 6'2". So we had to go through the administrative process, and maybe not quite as bad as when Bill C-31 came into effect, but you do have to go through a completely different line to now get your kid's status, because you are what they call, when I talk to them, an S3 case. So you had to go, to some sort of central area where they do this processing, and they have to verify that you are, all of these things, you had been impacted. So it took longer, and then COVID happened, and it took even longer to get my son his status. However, what they did was they verified all of that and changed me to a 6'1". And that's how they lengthen our lineage. So now my son is the 6'2", and my daughter automatically, since my son had gone through the process when she was born in 2022, then she automatically gained her 6'2" status and card. So why is the status important? So not only because of the treaty rights, which are tied to our status, which was, again, I'll reiterate, never intended to be tied to our status. Their access to those treaty rights, I think, is very important, because my ancestors were part of this. My ancestors were Treaty 1 members, as citizens of Sagkeeng. They were part of this negotiation. It was their intention and the intention of our leadership that we receive these rights that were negotiated for the rest of time, as long as the sun shines, the grass grows, and the waters flow. However, what is also really important about status is it really does, at this point, because of our history, tie you to culture and identity. It isn't culture itself, but it really does, kind of solidify you are a member of this nation. This was not the way it was meant to be, but it does really help with that identity piece. It's now just become part of that. And there's been so many different ways in which we've lost identity, whether it be through residential school, which, I didn't really even mention, but residential school itself, full of gender discrimination, in that it treated, the women, the girls who attended residential school differently than the boys who attended residential school. They learned different tasks. They had different expectations set upon them. And they also, were really enforced in these gender roles. They were expected to do sewing. They were not expected to achieve academically. I don't think there's a lot of reference that a lot of Indigenous children were expected to really achieve academically. That wasn't really the point of residential school. But I think women in particular did not have that expectation upon them, and were impacted by the enforcement of patriarchy and gender roles. And we see in the ways that that's seeped into our culture and our history and into modern life. And this all kind of paints that picture to what we're dealing with today when it comes to missing and murdered Indigenous women and girls. So these systems have been set up through the Indian Act, through acts of, cultural harm and colonialism that have really taken away a lot of the power from women in First Nations, women in particular, Indigenous women. And as I've kind of described, they've, suffered firsthand from that, but also from an intergenerational perspective, have suffered from this gender discrimination, to the point where it's also seeped into, not being able to vote, having our voice taken away internally, has also promoted lateral violence that we've experienced as well. So the systemic violence that continues to exist, wherein which Indigenous women make up 16% of all female homicides, and also 11% of missing women, yet Indigenous people only make up 4.3% of the population. So very disproportionately high. They're also 6 times more likely to be murdered than any other group. So again, why is that? And it's through all of these, these different types of harm, the different way in which gender discrimination has seeped into how we treat one another, how society treats us as Indigenous women, and how systems treat us. That has been pervasive in health. And I think just as a woman, I mean, we're not really represented in the healthcare system to an adequate or equal degree, in that a lot of research hasn't been done in a way that's focused on the female body. But women in particular, Indigenous women, have been often dismissed or have had active harm. Like I mentioned, there is also a history of forced sterilization, of also the impact of CFS impacts, where the family has been disrupted, where they have birth alerts, and that family continues to sometimes be disrupted. And the impact that has on a woman, because of what we talked about, at the beginning, about that role of being sacred, as being the life giver, as, being necessary to the family unit, it's continuously disrupted. And there are barriers, there continue to be ways in which Indigenous women face these barriers and continue to be marginalized. So we had, the Reclaiming Power in Place. This is the Missing and Murdered Indigenous Women and Girls, the commission. So the final report, I believe was 2019, and there's 231 calls to action to try and address some of this gender discrimination. So we're slowly, I think, as a society, moving towards addressing some of these harms, but they continue to exist, right? I was just at the Red Dress Alert pilot final report yesterday at the Canadian Museum of Human Rights, and this is just a roadmap. It's the beginning of how we're going to address this ongoing crisis. But there's a lot more work to still do. So I think I'm probably over time. So I think I'll leave it there. And maybe if there's any questions, yeah.
Karen Anishinaabe, New Zealand, First Nation woman from Barons of First Nation. I just had a question, like you talked about Bill S3. That's where my family is affected to this day. I'll just give you a little background, and I have a question about the upcoming maybe Bill S2. Yeah, because my grandma lost her treaty in 1922 on my dad's side. My mom married my dad. She lost her treaty in 1955. So then we get treaty back in, they did, and I applied in 1985 or a few years later. But I was married to non-status man, so my children have 6'2". So we went through this Bill S3. So 3 sons, one born before 1985 was recategorized to a 6'1". That's the Rama clause. But my 2 sons born after 1985 are just denied. That's it. The answer was no. But then I found out that if the parents were married before 1985, the children born after 1985 would qualify. So my youngest son has applied, and they say, well, this is a rare case. So we've been waiting, it's been 2 months, so we haven't heard nothing. So what I'm like, so I become an advocate for this. It's prompted me to write a book, and I have my books. And then I seen the pictures of my great-great-grandfather here, Chief Jacob Barons. So even though that lineage was there, it didn't matter because of the Indian Act, right? So, and then also my great-great-grandfather on my dad's side, Angus Mackay, was one of the persons involved with the treaties, but I don't talk about that. But I'm wondering, like this Bill S2, it's supposed to end the second generation, right? It's just been voted that the Senate voted.
Right.
So I'm going to a meeting in Ottawa, December 9th, a meeting with Assistant Deputy Minister of Indigenous Affairs to talk about this. Another colleague and I are going on our own. I've secured the meeting, and so I'm wondering, what are your thoughts about the bill S2?
Yeah, I mean, I'm obviously very much in favor of it not ending, because it never should end. This is another way in which we're really not allowed, because of the federal government, to determine like our membership, and that directly impacts our rights. So it's kind of crazy, honestly, that we are not really represented in how this happens, that it is up to the government. It is, I mean, the cynical part of me would say that it's because it's costly to have this go on forever instead of having all of these ways in which your status could end. But I'm for all advocacy, because like the thing that I think I'm a little trepidatious about it is that this is something the Senate voted, which is great, but the House has not. And typically things start in the House and then get reaffirmed by the Senate. Something going through the Senate, while great and shows that there is support that it wouldn't have to go through that, it's the lawmakers at the House level that I think are going to be the biggest challenge. So more and more advocacy, more people like yourself, more people like me who, you know, is very much interested in my line succeeding and continuing to be counted as, because if you're not, you know, you're a non-status First Nations person, things are a little more narrowed for you, unfortunately. And that's beyond, you know, the idea that you don't, you know, get your rights or your treaty rights. There's, I think, just an overall gap that shouldn't exist but does. So I think we could continue to advocate to write to, you know, your member of parliament and to really make your voice heard. And I expect our leadership from, you know, the local and provincial and, you know, beyond to also do that advocacy and protest. I'm in favor of peaceful protest, so.
Yeah, I wear this, I believe, because we believe it's going to happen. There's a colleague of mine, Mo Moody, that's doing this on his own, and I've joined his team, like talking to First Nation leaders, but it's going to some blind, like deaf ears. Yeah. Like, so we have to keep advocating. Yeah, if you're part of your community, my kids still we go to Sagkeeng, we go to community events, you know, if you're part of your community, why should the federal government say anything otherwise? So if we can continue to make our voices heard in that, I'm hopeful, but again, as a bureaucrat, I'm a little jaded, I suppose, at the same time, that the House could be a problem. So, thank you.
Maybe just a follow up to that, is there resistance within male band councils or any to that bill going forward? Or is it...
I don't think so. We really, and I mean, I can't speak for, you know, like the First Nations themselves, but there certainly is a return to, you know, the reverence for the role of women in society, in our communities, the advisory role of elders, female elders in particular. You know, there has been more and more female chiefs elected. There was just one elected, I believe Chief Bone in Sioux Valley was just elected or re-elected. She had been previously chief. And we have, you know, Chief Betsy Kennedy has been a very long time chief and advocate for female leadership in the province. So I don't think that there's a resistance at this point for female leadership or a resistance for from the perspective of Indigenous politics, I would think we would want more members, right? Because that gets us, you know, more resources because we're underfunded with the number that we currently have. So again, it gives us more power to expand and to be more inclusive of our people. So, well, thank you everybody for coming today.